The next major part of the bill is in lines 212. This has to do with the council's recommendation for increased judicial discretion in certain very limited circumstances, and in this circumstance having to do with drug trafficking. This nearly reflects the approach on the federal side, whereby if a defendant meets all certain conditions, and all of those conditions, then the judge may depart from the mandatory minimum sentence specified for a particular offense. If you look at lines those particular conditions are lines 215 to lines 221. The significant ones are certainly the defendant was not a leader of criminal conduct, the defendant did not possess or use a weapon during the crime, did not result in death or a serious bodily injury, and the defendant has no prior felony. And of course, line 220, the interest of justice will not be served by the imposition of the prescribed minimum mandatory sentence. What this will do is, if the defendant meets all of those conditions, all of them, then the judge may depart from the minimum mandatory no more than 50% of the sentence. I will tell you that this will have very narrow application, and that's by design. We want it to be difficult to achieve, but by the same token, we do want to balance that out with having increased judicial discretion. There will be situations in consultation with judges in general, certainly through the testimony of the chair of the council, Court of Appeals Judge Mike Boggs, who used to be a Superior Court judge down in Waycross. You are going to have those situations, and again, the prosecution testified to this as well. You will have those situations where there will be a defendant who may not warrant the minimum mandatory. That is going to be a case-by-case analysis, of course, dictated by the particular facts of that case. I will tell you that, as I said before, that this will apply to a very narrow potential population. I think that's illustrated best if you look at line 219, the defendant has no prior felony conviction. We got some data, Mr. Chairman and members, from the Department of Corrections. We have about 2,600 individuals who are in the state system right now for drug trafficking. Of those approximately 2,600 individuals, less than 5% of them, less than 5%, had no prior felony conviction. So if you add in the further conditions of was not a leader of the criminal conduct, did not possess or use a weapon, the conduct did not result in a death or serious bodily injuries, the number of people who are really affected is actually much smaller. And that, again, is by design. We don't want to open the floodgates for this possibility. By the same token, but we do want to establish the possibility of a downward departure in the sentence if the facts warrant it and if all of these conditions are maintained. And just to make sure it's clear, the downward departure by the judge, if the defendant meets all the conditions, cannot go any further than 50%, cannot go any lower, I should say, than 50% of the mandated minimum mandatory. And we thought that was a proper balance. Section 8 goes to the area of serious violent felonies and the possibility of a downward departure in a minimum mandatory sentence as it relates to serious violent felonies. In this situation, there is no ability of the individual to meet certain conditions to get that downward departure in the sentence. We limited it to just where the prosecuting attorney and the defendant have agreed to a sentence. And you see that in lines 439 to 442. We limited it just to negotiated plea as opposed to the meeting of the conditions in the drug trafficking situations. Why? Because it's a serious violent felony. And because the level of the conduct rises to a certain, obviously more troubling level, we felt that the ability of a downward departure of that minimum mandatory should only be possible if it's a negotiated plea, if the prosecuting attorney and the defense have agreed to the sentence. And just, Mr. Chairman, one thing just to make clear, both in the serious violent felony context and in the drug trafficking context, and you'll see identical language in both sections. I'm just looking at it here. In this particular section, line 443 to 450, it just makes very clear that this there would not be any possibility of pardon, parole, commutation of the sentence by the State Board of Pardons and Paroles. However, during the final year of incarceration, a defendant sentenced under the minimum mandatory would be eligible to be considered for participation in a corrections administered transitional work center or work release program. So if they do have a downward departure, they serve every day of that particular sentence. So if it's a 10-year minimum mandatory, but they actually end up only getting sentenced to 7, they serve every day of that 7, with the exception of this transitional program referenced in lines 449 and 450. We have the repeating language for punishment of sexual offenders, lines 456 to 457. Again, in that more serious situation, that downward departure would only occur with a prosecuting attorney and the defense have agreed to that particular sentence lower than the minimum mandatory.